Welcome inside another episode of the Brooklyn Boardroom, where we go behind the curtain and off script with stakeholders and foot soldiers in media, tech, and entertainment. And today's theme or question of the day is going to be how to handle legal disputes, claims, and controversies. And, we have two luminaries in the room today to help us figure that out. Today's stakeholders have been educated at some of the finest institutions in the country and have worked for some of the most prestigious law firms and organizations out there in media, tech, and entertainment. And that's my man, Bobby Mason and Lawrence Hinkle. Welcome, brothers, to the Brooklyn Boardroom.
Thank you.
I don't think we ever had this three black men in this room at one time, so amazing things are gonna happen, right? This is called Black Gold, right?
Yeah. Thanks for having us.
Black, excellent. No, thank you for making the time, bro. I know time is money, literally, in your business because you work for a law firm.
That's right.
On an hourly basis. And this man right here is Big Cheese up at Lionsgate, my former employer. And he's a senior vice president, actually, just because that's not in the title. I want people to understand how heavy you are in the game. So before we get started, I just want to give people an idea of kind of your backgrounds and kind of the work that you guys do. And then we gotta walk through three phases of this conversation. The first is helping people understand the landscape. What are the fundamentals to legal issues, right? The second is what's happening in today's marketplace. And the third area is going to be how to be woke and surgical in the marketplace, right? But again, before we get into that, a little backstory. Mr. Mason here, Robert, you're from you're local guy, right? From Los Angeles, specifically where though?
I grew up in West Adams, off Crenshaw and Adams.
West Adams. Any Crips or Bloods you want to shout out in the process of that?
Not in a permanent format. I got to get home safe.
All right. So you're a local hero, also former baseball player, baseball star actually, right?
I had my moments.
Yeah,
I got hurt. I was one of those guys that coulda, shoulda, woulda, but didn't.
Recruited to Amherst College on a baseball scholarship, right?
They didn't have a scholarship, but I did play baseball there.
Got it. Went on to you did your undergrad at Stanford?
I did undergrad at Amherst Law School.
Amherst, and then your graduate work at law school at Stanford.
Right.
That's right. All right. And then Lawrence, I don't know too much about where you grew up, man. I think I forgot. Where you from originally?
Army brat.
Oh, okay.
So, yeah, my dad was in the Army and traveled all around the world and across the U.S.
Any particular city or town you claim is yours?
No. Well, L.A. now.
Okay.
Yeah, I've been here my entire career in undergrad and all that.
I hear that. And remind me again, I know you went to
UCLA undergrad and UC Hastings Law School.
That's right.
Yeah.
And then right now you're practicing with Fox Rothschild. You're the lead. You're the managing partner?
Well, no. I am the chair of the Entertainment Litigation Practice Group.
That's a pretty big title, brother. I applaud to that. Hold on one second. When you guys hear this sound, that means we got a heavyweight. Something heavy has been said. We got a heavyweight in the room. We got two heavyweights in the room tonight. All right. Chair of say it one more time.
Entertainment Litigation Practice Group.
Entertainment Litigation. So clearly you are an expert for purposes of our conversation at least, in litigation matters as it relates to entertainment and media. You've seen a lot of things. You've been, probably a part of a lot of messy lawsuits. So you can kind of help the entrepreneurs and the folks that are trying to segue into this business. You can help, both of you guys can help those people navigate around those problems or circumvent them when possible, which is what we're trying to do here. You know what I mean?
Yeah.
So great, man. You're never this quiet, Lawrence. You know what I'm saying?
Man, I'm waiting to jump in.
Don't you guys get fooled. This seems like a quiet humble brother. He's a beast in the courtroom, man. You know what I'm saying?
No. We do what we got to do when we have to do it.
I hear that. Talk softly, but carry a big stick, right?
Mm-hmm.
And this dude right here, you acting all quiet and shy, but
I'm deferring to my hero over
but
here.
I've seen you grab alligators with your bare hands. You know what I'm saying? So
it deserved it.
Well, listen, brothers, you guys are the gladiators of our business, at least from my point of view, because when something goes down, you don't look for your tax lawyer, you don't look for your accountant, you look for your litigator. You either want to go after somebody's throat in a courtroom, or you want to defend your own throat because someone's coming after you, right? So you guys are definitely the gladiators when it comes to legal practice. Hats off to anybody who's in the litigation field and doing it for a living. So let's jump right in because these gentlemen have a lot going on, and we're gonna get started with these questions. So here's a basic question to kind of again warm up our audience and also kind of give you a sense of the direction of our convo. So what acts or omissions? When I say acts, I mean things people do. This is for the purpose of folks who don't know the legal world. Things people do, by their own volition, right? Or omissions, things they should have done but didn't do. So what acts or omissions in media or entertainment transactions customarily lead to a legal action? Whether we're talking about copyright infringement, trademark infringement, breach of contract, what do people do right? I mean, what do people do wrong by their own behavior or by what they fail to do? Typically.
Yeah. Well, I'll
Either
jump
one
in.
of you.
I'll jump in real quickly. One of the fundamental problems that I see oftentimes, and remember, we see problems when things go wrong. They're already gone wrong. And one of the consistent things that I see is that people do not lawyer up in the beginning, right? They do not get good legal advice in the beginning, whether that's, hiring a lawyer at all or investing in the right lawyer to help them navigate the legal issues as they're putting a deal together or they are launching into a business or an industry. So I would say, first and foremost, get a good lawyer. And then the second thing I'll say is, one of the biggest issues that I've seen is just basic drafting issues and problems within a contract. Oftentimes I see contracts that are too ambiguous, that do not address the terms in a clear and concise manner, which leads to differences of opinion down the road about what is required to perform. And in addition to that, I often look first in a contract. I mean, a lot of lawyers look at, transactional lawyers especially look at, how much money is going to be paid, what kind of type of credit you're going to get.
That was me, guys. I'm looking at the money.
Absolutely. Yeah. And that's 99.9% of the rest of the world. But as a litigator, we oftentimes look at the boilerplate, what people call the boilerplate. What is the choice of law provision? Is there an integration clause? Oftentimes that's where an attorney's fees provision would be. What form we have to litigate in when there's a dispute. All of those types of issues for a litigator are extremely important and may help to decide what the ultimate outcome is. But also importantly, depending on what those terms are, they may oftentimes help you avoid getting into a litigation situation because it gives you leverage, it gives you other tools to try to persuade someone else not to continue with a dispute. But also, it is the first mechanism we look at to make sure that our client is well positioned, when a dispute arises.
I want you guys to pay attention to what this man said. Lawyer up out the gate, meaning get legal consultation from competent counsel before you press send on that email because you drafted something that has legal implications, or before you put pen to paper and call yourself putting together a contract. Get legal advice or a lawyer to handle it for you. Otherwise, you're going to probably get yourself into trouble if something goes wrong with that particular transaction or deal, right? So
I'll just add on to that too, that that's good advice for actual lawyers too, for transactional attorneys, is that, as Lawrence said, we usually get involved after things have already gone to pieces, where you could have brought the litigator in to help maybe even draft the, understand the context in which the contract is being drafted. You can get specific provisions in there, for example, like a mediation provision, which is something that's highly useful for a litigator. That's flexibility. Transactional attorneys, I think, sometimes think more like business people, and they start drafting things without an eye towards litigation, whereas everything we do...
Unless they've been sued, then you learn a couple of things.
A couple of them do, yeah. They learn a lesson, and they learn to call you in on the front end, and it gives them some cover, too. They could always say, hey, the litigator signed off on it.
That's right.
But in terms of kind of crafting the agreement and the relationship from the ground up with an eye towards possible litigation, because some disputes are always going to come up, whether it actually ends up in litigation or not. Usually has to do with some of the practical concerns that Lawrence was talking about. But there's going to be some point where you're training fire on each other, and you want to be as protected on the front end as you could be.
Because you gentlemen are well experienced in thinking about what can go wrong because of a grammatical issue in a contract or an actual breach of contract for someone not doing what they're supposed to do. So you guys have seen lots of scenarios and also think creatively about what could go wrong and what do we do when that happens. So you see a piece of paper in front of you, you're like, wait a minute. You know what? If you leave that there, then and this becomes a problem, we're going to have to do this. It's going to cost you that, right? So
that's right.
So that segues great into our next question, which is, because you mentioned mediation. So what are the traditional legal forums and approaches to deal with legal claims or actions? So, for example, you mentioned mediation. Arbitration is something people have heard of before, court of law. So what are some of the forums and traditional ways to approach legal issues?
Well, those are the big three. I mean, there's, you can either file a lawsuit, you can have arbitration, or you can have and they're not mutually exclusive, mediation at least. I mean, a lot of times mediation, sometimes there'll be a mandatory mediation clause where you've got to mediate if a dispute arises, and then you either end up in arbitration or you end up in court. There'll be a specific arbitration provision normally.
We're gonna just dial this back a little bit because we need to park and unpack this for those who don't have JDs and don't have any concept of legal forms. What exactly is mediation and what exactly is arbitration, and how do the two differ from a court of law?
Well, I mean, they're streamlined. Arbitration in particular is a streamlined version of judicial proceeding. You're going to get an actual adjudication by a judge, maybe 3 judges, depending on how it's set up, and you're going to present your case in a similar way that you would present it in court, in trial, but just much more streamlined, a lot less formal. The rules of evidence aren't as powerful and as strong. It's cheaper, and one of the big benefits of arbitration, if done right, if the arbitration clause is crafted correctly, is that it's also confidential. So your company and your witnesses' names aren't splashed all over the Hollywood Reporter as soon as a lawsuit is filed.
Well, let me amplify that because I think that's important. You hit on some really key things. Arbitration is faster, it's cheaper, and oftentimes it's the more practical approach. However, you need to make sure in that arbitration clause of your contract, you have a confidentiality provision. Otherwise, as it relates to traditional court, that information or those pleadings, that the paperwork you submit is subject to public exposure, right?
Right.
Okay, so if you don't want to get out in the press about what you did with whom and how, then maybe go to arbitration. Let me ask you a question, though. Can you actually still have that confidentiality, that privacy in a judicial proceeding, in a court versus arbitration, if you end up taking it straight to court?
Lawrence can answer this much better than I can, but you can get things filed under seal and everything like that. But those are pretty onerous things to get done. I mean, I think generally your presumption should be if it's going to be a lawsuit, it's going to be public.
Yeah, it's in very, very rare circumstances are you going to be able to go to a court of law, whether it's federal or state court, and not and be able to keep them out of the public eye. I mean, one of the fundamental things about our judicial system is that it's a public forum. And so Bobby mentioned the concept of filing something under seal, and that really pertains to a document or something that is highly confidential or maybe prejudicial to a party, where you have to go through a very specific process and asking the court for permission to file it under seal. That is also different from the notion that the actual hearings or the trial will be private. So if there's a trial, the public has a right to sit in the courtroom and see what happens, and we've seen that on our television screens year after year after year, right? So that's very rare. In an arbitration context, the public does not have a right to be in the room when the arbitration is going forward. And so I think what Bobby is referring to is private or confidential in a way. However, most standard arbitration provisions do not include a confidentiality provision that prevents the parties from talking in public about the fact that the arbitration is going on, what happens in the arbitration. So if you are interested in keeping what happens in the context of an arbitration private, then you need a specific provision in a contract that prevents either party from disclosing to the public either the fact that the arbitration is happening or what happens in the arbitration proceeding itself. That being said, right, one of the things that I wanted to mention is that when you get an arbitration award, that award in and of itself is just a contract. So, for example, if you go to arbitration and you get a $10 million award from an arbitrator in your favor, in order to enforce that, if the other side does not agree to pay that $10 million right up front, and you have to go and enforce it, the way that you enforce an arbitration award is in the public court system. That requires you to file your arbitration award in a public forum so everyone can see. And there's nothing that will prevent that the other side can do to prevent you from doing that, with the exception of asking a judge to allow, to require the filing of that to be under seal. But that's going to be a very, very rare circumstance for that, for a judge to grant you that sort of relief.
Wow.
And then the one last thing I wanted to say, you asked a question earlier about differentiating between, court systems and arbitrations. One thing, I think Bobby hit on all the main points, but there's another very important thing about arbitration that's different than the court system, and that is the arbitrator basically makes a ruling, and the arbitrator doesn't necessarily have to follow the law.
Oh, wow.
Right.
Wait, hold on. So, wait. We got the arbitrator can do what he wants to do and not follow the law?
Most good arbitrators
job I want.
do follow the law. But if an arbitrator does not follow the law, there is no right to appeal in most arbitration provisions. So you can't take a wrong ruling or incorrect ruling because someone didn't follow the law and appeal it to a higher court in most circumstances. So you're stuck with that ruling and there's no recourse after that, as opposed to when you are in state or federal court, you can get a bad ruling from a judge or jury and appeal that ruling to a higher court.
I'm so glad you said that because arbitration was sounding so great. It was sounding like the panacea. It's all our problems. Save money on court, be able to expedite the situation, get it. Maybe even get them to sign a confidentiality document, and you're good to go. You know what I mean? But there are some drawbacks to arbitration, which you just described, which are basically the issue being that if this arbitrator doesn't do what the law would traditionally instruct a judge to do, if he doesn't, you're stuck with that ruling. So clearly, you need to pick wisely when you pick your arbitrators, right?
Absolutely.
So now, you briefly mentioned or referenced federal court, I guess, versus state court. I'm just wondering, and I know you have experience in all these various forums. I'm wondering, is federal court relevant for any purpose in terms of civil litigation? Again, party A sues party B for contract breach, or company A sues company for contract breach. And we all know there's state courts, federal courts, appellate courts. There's the Supreme Court. Like, is it to what degree is any of that relevant in our traditional, typical breach of agreement scenario?
Yeah. There's generally two ways to get into federal court. Mm-hmm. One is when you have what's called a federal question. It's a type of dispute where the federal courts have exclusive jurisdiction. So all of the IP related disputes, intellectual property disputes, copyright, trademark, patent disputes, all must be tried in federal court and cannot be tried in state court.
That sounds expensive, right? Or more expensive than state court, is it?
Well, not necessarily.
Okay.
And there are advantages and disadvantages in being in federal versus state. I tend to think that federal court is more streamlined. It's less wiggle room. We could go in that in a.
I bet you the brothers in federal court got nice Armani suits, man. Versus those local lawyers in the state court. I've seen some of them guys. They just come through there dusty. Yeah. No offense to anyone watching this who's dusty, but I'm just saying, federal court, they seem like they're official.
Yeah.
Right?
Yeah. Well, they are official. Yeah. And I know some state folks who practice in state court too, but a lot of people practice in both places. So anyway, in any event, there's federal question issues. So I mentioned a few, IP, admiralty cases, bankruptcy cases, all federal court. So that's a federal question issue. And then also what's another way to get into federal court is what's called diversity jurisdiction, which is you have to have a dispute where all of the plaintiffs and all of the defendants are from different states, to put it simply. And so if you have two of the plaintiffs are from California, but all the rest of the plaintiffs are from Florida, that is one of the steps to try to get into federal court under a federal question. Under diversity. In addition to complete diversity is what that's called, you also need the dispute to be at least $75,000 in damages alleged. So if you have both complete diversity and the minimum amount of $75,000 at issue, then you have a right to file your claim in federal court or remove the case that's been filed in state court to federal court.
So check it out, all you SAG-AFTRA actors who didn't get paid your per diem. that will not allow you to take your claim to federal court. Your $200 is not going to do it.
Right.
You might as well just show up at his office and just threaten to break his legs versus trying to take him to court, federal court at least. Very helpful, man. Very, very helpful context here. Okay, so let's move on a little bit. So we covered some of the basics. I feel like the folks watching it should have they may not have JDs, but they definitely on their way to earning one with you guys in the room. So let's move on to exploring the current landscape, right? So my question to you is this. And this is for those of the audience who are either building companies, have companies, one day want to have a company, or just want to understand how these legal issues are handled within organizations because they may be entangled in something at some point in time. So how have large media companies traditionally responded to claims you discussed earlier, trademark infringement, copyright infringement, and what factors do they customarily consider before officially responding, right? Because we know sometimes, you don't even hear of a claim because it's going to be bad press. So they just kind of put it under the rug. They may be taking things to arbitration and getting things sealed. So I don't know, either one you could talk to this. Like, how is that stuff traditionally managed inside a big organization that has a lot to lose?
Well, I can speak to some of the typical issues that we have at a company like Lionsgate. We own a lot of intellectual property, and a lot of the claims, you'll get regular slip and falls and sexual harassment claims and things like that. But the bulk of what our business is selling and licensing and acquiring intellectual property. So a lot of the claims, they become, none of it is rote, but they do get to be a little bit predictable. You know what types of claims you're going to get. You put out a movie that's successful. Part of the downside of having a successful movie is that people are going to come out of the woodworks and say, oh, you got a vampire movie. Check out this script I wrote when I was 12 on vampires. And some of those claims, they all have the same elements. So you start to assess them according to not quite a checklist, but you got a little decision tree. Is there any merit to it whatsoever? Like, do we know right off the bat, just based on the timing? Like, we know when we wrote our script, and you're saying your script was written 40 years later, we got you dead in the water. Now the question is, do we write you a letter memorializing that could end up on the internet and giving you the attention that maybe it's the attention that you wanted in the first place, or do we just ignore it and hope it dies on the vine, running the risk that this person might rush to the courthouse and try to get a declaratory relief action against you or something like that? So we go through the whole gamut. I mean, cost is obviously a big issue, whether or not we want to do business with this person in the future. If someone's got a valid claim, we want to know that too. We want to be honest about it. And the thing is, we were kind of talking a little bit off mic about how creative people always think that their idea was original. They think,
of course,
and there's not that many different ideas under the sun.
Of course.
And it's very rare in this space that someone is actually stealing from you, that someone's actually just copying your idea. Did you put it up on the internet? Was it possible that somebody stumbled across your YouTube video and was suddenly inspired and then went off to rip off this movie trilogy that made over $1 billion all because of your YouTube video? Or is it just as likely that they came up with the idea that you think is so great on their own? You want to think about that. You want to think about the publicity. One of the things I've learned and one of the things I was told and taught when I first came in-house versus being inside of a law firm was that, they're like, you write good letters, but you write lawyer letters. You got to start writing business letters. Like, even if they're dead to rights wrong, we might be doing business with them next month.
Well, we got to pull up on that. Hold on. That's an important factor. Even though, I'm just want to amplify this and you can jump right back in. Even though you're in a situation where you may be in an adversarial situation with an outsider, and as you engage them to figure out this issue, you've been instructed, or the general conventional advice is, don't create a document that's gonna ratchet up the tension and make it more adversarial. Temper that language, that messaging, so that there's room for a relationship afterwards.
Yeah. Don't burn down the house. I mean, that's what I was kind of known for, was pulling out the flamethrower and just letting everybody have it. And when you're in house, especially, it doesn't matter how heated it gets. If we can make money on a deal 2 months from now, they'll make money in a deal. And I was like, well, I'm glad you guys told me that, because I was about to go get them. But the better bet is to try to maintain a business, cordial business relationship, get your issues out, advocate for your position, and then call Lawrence when it's time to start breathing fire.
Like the Corleone say, man, it's only business.
Mm-hmm.
Luca Brasi sleeps with the fishes. It's only
right.
business. I'm gonna lay something at your feet, Lawrence, because Bobby just tuned this up perfectly just for you, because you're on the other side of this, and you oftentimes represent people who make the bad decision. So what fact pattern tends to be the one that leads to a client of yours who is at an organization having to cut a big check because they didn't do what they were supposed to do? What fact pattern tends to lead to that result for one of your clients?
Well, I mean, it always usually comes down to the human factor, right? You have a large organization that is made up of people, and oftentimes people make mistakes. Some people do not do what they're supposed to do to comply with the contract within these large organizations. Maybe there are checks and balances that are overlooked because someone is just too busy. Maybe some people just get it wrong. I rarely see a situation where, someone is doing something intentionally wrong, right? Most of the time in these large organizations, everyone is well-intended, but mistakes happen. And mistakes happen through omission, as well as, affirmative acts. And so when I get involved, one of the most dangerous places and the places we look after looking at a contract or after looking at some of the IP issues is emails, right? People send emails not understanding. People send dozens of emails a day, not necessarily understanding that what they say about a particular project can be Exhibit A in a lawsuit, or certainly the smoking gun email.
That's right.
That a jury sees at trial. And so I tend to see and advise my clients to really be thoughtful on a day-to-day basis. Not everything needs to be put in an email. Not everything needs to be said. Consult when things get sticky. Consult your lawyer before you respond, and just don't think you're the smartest person in the building.
Wow.
And so when the big checks are written, there's various reasons why that happens, but oftentimes it's because of a confluence of different things, like the contract is not as well drafted as it should be. People don't do things the perfect way that I would have wanted them to do as their lawyer defending them in court. And so, most of my clients don't write any checks versus big checks because, one of the things that they hire someone like Bobby or myself for is, to not be a one-trick pony, right? To be smart, to outsmart the other side, to figure out what the best way is, really to get the company out of the problem for the least amount of money. And sometimes you pay the other side to do that, and sometimes you pay your lawyer to do that. But we have to, be this, we're playing chess against some of the best chess players in the world, and we have to say checkmate one day.
The game is chess, not checkers, brothers.
That's right.
Like what was his name? In Training Day, what was his name? The character's name.
Denzel's character?
Yeah. Antonio, right? Or something like that?
Something like that.
Anyway.
Lonzo.
It's chess, not checkers, right?
Yeah.
Games, you know what I'm saying? Listen, on this show, I invoke a lot of film, dialogue and scenes because it's just my thing. You know what I'm saying? Way to communicate with the audience,
All right, I might get some Pulp Fiction lines in here.
Yeah, I'll try to find the millennials are looking at everything. But you just mentioned something that's really important, and I don't know if you finish your point. Did you finish?
Yeah, that's fine.
Oh, okay. Oh, but you're dovetailing into something else that's really, really relevant and well said on that last point, by the way. So piracy, right? So here's what happens sometimes. Like you said, sometimes it's appropriate to send an email. Sometimes, hey, that may be better dealt with in a meeting, Mr. John Doe with Mrs. Jane Doe, versus having to put it in writing. So, and we've seen in our business organizations get in a lot of trouble because too much was in writing or not enough was in writing, right? So we all have to kind of think about, how to handle these situations, with the right type of attention and taking into context how delicate these things can be. because there's a myriad of issues we can be dealing with. We didn't even get into like sexual harassment, age discrimination, gender bias, all these things and some of these things are protected classes under the Constitution. So again, for those that are watching and listening, be mindful of what you're putting in writing and be mindful of what you're not putting in writing. But the first thing to do is talk to a lawyer. So here's my question on piracy, right? So what about when the infringing party is a particular, is really difficult to get to? Like they may be based in China, or it may be, a mom and pop business that's gonna look really bad if we sue them and bring down a house on them. Like, this is not to deal with piracy. This is another question, but I want to still deal with piracy. But like, what do you do in that situation in terms of strategy? Do you take those things into account? Because listen, I wouldn't even begin to tell you if someone infringed on my rights from China, how I would even go after them, let alone, deal with that issue, right? Them pirating the show or them stealing some IP. So is that relevant? The region?
Well, where there's a will, there's a way, and when there's enough money, you can train fire almost anywhere around the globe that you need to. But everything is a cost-benefit analysis. I mean, are you going to go spend $100 grand, $200 grand, $300 grand to chase down somebody in China that's going to just pop up again like whack-a-mole after you spent your $300 grand? And what are you really trying to stop? Are you really trying to get there to be zero infringement? Is that your actual goal? Because you're going to lose that goal. You're going to lose that battle. And yeah, sometimes you've got fans. Like you've got movies that are so successful that people have an emotional attachment to them. People infringe, and they're either innocent infringers or they're infringers in good faith. We get a lot of, we want people to be attached to our films like La La Land or Hunger Games and Twilight. You got fan bases that really love these products and love these films and love these properties. And these days with technology, anybody can go rip off a poster. They can design their own T-shirt. They can make their own cup. And a lot of them aren't making, they're not running these things off in the garage and making hundreds of thousands of dollars. I mean, sometimes they're doing it just to show their love for the, for the property. And you have to make that decision. Is it worth even going after this person? You might get that PR blowback that we didn't want. Because sometimes the tools that we have at our disposal don't include a scalpel. Like sometimes it's all sledgehammers and broadswords. You can't always deal delicately with folks when they're committing what's essentially, a federal crime. Counterfeiting is a federal crime. People don't think about it that way when they're designing their own La La Land T-shirts or their own Twilight, sleeping bags. They don't realize that there's serious penalties here.
Federal offense.
Yeah,
I'm just curious, has anyone that you guys know of ever gone to prison for something like this? Federal prison because they've pirated DVD copies on the black market, and that's. You guys know? I don't know anyone personally. I'm just wondering if.
Yeah, well, I mean, there are certainly occasions where enforcement, criminal law enforcement gets involved and seizes property and does go after folks. Mm-hmm. And I think a word to the wise is you may be in China, you may be in Africa, you may be in Europe, but I also think as part of this global economy, we can find you too. Right. I don't think there are too many places you can hide these days without someone being able to enforce their rights to try to stop you from doing what you're doing. I think a lot of the times the issue is going to be, as Bobby said, is it worth our time as a company to spend our resources stopping the one guy selling T-shirts on an island that we know does not make a lot of money?
Or even 125th Street at home.
Or that too. Right. And so that's a business decision that the company has made. And I think that also leads me to think about a non-legal issue with a business decision. And I see a lot of companies just investing in things like their privacy, the encryption things before things go out, and how things can be distributed on the internet, and making it more difficult for people to infringe, making it more difficult for people to copy things, making it easier for people to be able to take and distribute what you have, or open up your movie that's encrypted in a certain way in a certain territory. I mean, it's becoming extremely sophisticated. And I think a lot of investments going in on that end, in addition to the backside, which is the enforcement issues that we've been talking about.
Let me ask you this, and this is something that's going through my mind, may also be going through the mind of some, very junior creator, independent filmmaker. And the thought is this: I make a movie about your garden variety story or topic, but it does really well. People love it. And all of a sudden I find that it was pirated, meaning like someone from some other region of the country, outside the country, was like, yo, that's dope. I'm putting that out everywhere and making $1 on it, right? So one point of view I may have is, look, wow, clearly, when people steal from you, that's a sign that you got something valuable, and maybe that's okay, right? So maybe I'm losing a couple $1,000s, maybe more than that, I don't know, but maybe my point of view is the more people that see it, the better. But if I decide at a later time to, or have a change of thought and I want to enforce those rights, did I lose anything by just sitting back and letting this guy make 1,000 copies or maybe 500,000 copies of my film, selling it all over the country? Did I lose anything by not enforcing my rights immediately and waiting like a year or 2 or 6 months?
Well, I mean, it's case by case scenario situation, especially with regards to trademarks. You have a duty to, you can't sit on your trademarks. You actually have to go police those marks. There's just a basic statute of limitations issue where if you sit on your claims for too long, somebody's infringed, you do run out of time at some point. In copyright, if people reproduce or republish something, the clock may start again, but you may have been cut off from a certain amount of damages. But yeah, I mean, for the most part, you can't sit on those rights. If you see somebody that's infringing and it's at a large enough level that you ideally would take action, you should consider taking action. I mean, you don't lose your rights completely because you own the stuff and what they're doing is wrong. But yeah, I mean, you could lose out on damages. I mean, you could lose kind of like the moral high ground.
Interesting.
If you let people kind of string themselves out a little bit and just kind of let them, compound their whether it's a mistake or if it's intentional. So yeah, I mean, you should always act. I mean, you should definitely be proactive. Now, realistically, you can't go after everybody, and the law doesn't require you to go after every single instance of trademark infringement, for example. But you do generally need to be policing it because you can, it's called abandonment of a trademark. You can actually abandon a trademark just because you're not enforcing it or protecting, and going, taking some action against people.
It's like, what is it, like squatters' rights? Like you go in someone's house. What is that called again from law school? I forget.
Adverse possession.
Adverse possession, yeah. Like
open and notorious.
Yeah. You open and notorious. That's the acronym, I think, for the.
It's like,
that's one of the
elements,
categories.
It's
Yeah,
got to be open and notorious.
But the whole idea is, you find someone's house. Oh, this is nice. No one's here. I'm gonna just move in. Mm-hmm. You're there for 5 years. Obviously, this is not the legal, criteria. But you lived there for 5 years. All of a sudden, the person who owns the house no longer has a right to claim it because you adversely possessed it. Right? You took over. Sounds like that concept also exists in the area of enforcing your trademark or your copyright. Right.
Something similar, if you want to get, like, for example, if you want to get like an injunction against somebody to stop somebody from doing something that you think is infringing, one of the things you got to establish is that there's kind of like an irreparable harm. It's like, well, how can you argue that a harm is irreparable if you've let it happen over and over in different situations for X amount of time? It doesn't seem like it's that irreparable. It seems like you sat on it for a while, But yeah, for the most part, lawyers, you spot it, you got to make a business decision as to whether or not it's worth going after in any particular circumstance. But just in general, yeah, you need to be actively policing all your marks and your copyrights.
Okay, great advice. All right, so we're moving into the third element of our conversation, and it's about being woke and surgical in the marketplace, right? So this is where we try to bring everything we learned to bear on best practices and how should we be moving in these streets, more or less, right? So my question to you is this, and you've actually already touched on this last one I was going to ask you. Let's see. But let me ask it anyway. So what types of claims or legal issues, if gone unchecked, tend to be the most explosive or problematic for an organization? And there's a ton. You talk a little bit about piracy, copyright infringement, the sexual harassment. Is there like one or two things you're like, listen, man, if you sit on that, you're going to be in big trouble, or are they all kind of in the same category?
Well, I think it depends. I mean, every company's different. Mm-hmm. Every company has a different sensibility about certain things. So maybe a younger company that's trying to establish itself in the marketplace may need to make sure that their trademarks are protected and they vigilantly defend them. And they, as they're establishing themselves not only in a particular, territory, but certainly throughout the world, you need to Make sure that someone else isn't establishing that company called Uber in Germany or in Florida when you started your company here in LA. And maybe that name is so important to your business that you will go, it's a bet the company type of issue. And so certainly, you can think of a myriad of different types of situations that where a particular type of issue is important to a particular company. And you mentioned, sexual harassment. Well, I mean, if your CEO has that allegation against him or her, it may mean the life of the company to deal with that situation appropriately, because maybe that CEO is so important to the company, or maybe defines the company, so that you have to figure out a legal and PR way to address it and resolve it in a way that will help the company survive. So it really is a case-by-case basis.
I'll say one thing. I mean, look, considering, all that's going on with the sexual issues with Harvey Weinstein and other people, I mean, I feel like I lost count of the number of men, and maybe, I don't think any women have been identified, but men that have been identified as, predators and abusive in the workplace towards women. I would say if you have an organization, big, small, tiny, tall, whatever, I would be very sensitive about any claims you receive in connection with a sexual harassment claim, because that area right now is on fire, clearly. You know what I mean? And it's a scary place to be right now if you own a company and you're having to deal with messy things like that, right? So on that theme, obviously today's workplace is very hypersensitive and we live in a world of political correctness is everything, especially in the workplace. How should executives, creators, businesses be managing these potential legal issues that can arise in the workplace? So if a person is a victim of abuse in the workplace or as part of a production, what are the first steps they should be doing to preserve their rights, right? And then also the same is true for the other side. If they own a company that has been alleged to be the offending party, what should they first be doing to preserve or protect their rights?
Well, I think, ounce of prevention is worth more than a pound of cure. I mean, I think investing on the front end in training, getting your protocols together in case something does come up, getting all that done on the front end is much better way to approach it than to wait till things have blown up and trying to put the cats back in a sleeping bag. I think in some of these issues that we're seeing now that are kind of human-based, discrimination or harassment and things like that, what the actual law says and what HR policy should be aren't always necessarily as intuitive as one would think. Like just trying to address these things based on your instincts or thinking, hey, I'm a good person. I'm a well-rounded person. I was raised correctly. I couldn't possibly be a harasser, or I couldn't possibly have, be someone that discriminates. And we see what the actual standards are and what types of, how easy it is to kind of cross lines even without having bad intentions. And so I think it's important that people are aware and actively thinking about the potential, potholes that are out there, as opposed to waiting, counting on your ability to kind of react. These things they require you being proactive. I mean, society's standards change. I mean, mores change. Keeping up to speed. When you realize like you're actually at work, like this is a business. That we have interpersonal relationships. We've got friendships. And we're human beings that we interact, but we're primarily there for business.
Wait, are you suggesting we can't be dating the assistant? Is that what you're trying to tell me?
Saying that
you can't take out the interns?
Saying that explicitly,
Okay.
Yes.
Yeah, but I'll let me add to what Bobby's saying. Preventive measures is obviously extremely important, but let's be real. I mean, things are going to happen, or certainly, without question, things are going to be alleged.
Definitely.
Right? And so just as important as the preventative measures being in place, you have to have policies and procedures in place to deal with the allegations that are made. So that means having an investigation process and procedure set up, making sure the employees and staff know what to do when they feel that their rights are being violated in that way. Maybe the investigation piece is internal through your human resources department. Maybe you farm that sort of thing out to a law firm to conduct the actual investigation. But it's that process of having the system set up, having the right advice from the HR group or internally or the law firm outside, and what to do to correct any measures that have correct anything that they do believe has gone wrong. All of that is extremely important and may affect whether or not the company survives, maybe in general, but certainly, how much money may come out of the bottom line, even in situations where the allegations are not true. You may have to pay because you do not have the right processes and procedures in place.
You guys both, touched on something that's really critical, which is, big or small organization. Obviously, the small ones should be listening to this very carefully. It's like you have to have structures, procedures, methodologies, things in place to just deal with and vet these issues. Because if you don't, you're going to be in big trouble and may find yourself in court just because you didn't know how to deal with it. Just because you didn't have an investigation, you didn't have an intake form, you didn't have a document disclosure. A document that someone signs disclosing certain things in their history of the past. You may be hiring a pedophile for all you know, right? So I think that's a really, really good point. It's like, keep in mind that this is a business and it has to be treated like a business, which means you got to be responsible and structure it internally as a business and take these allegations serious, right?
Right.
So final question for the folks out there who, are looking at you two saying, man, he's got a nice suit. He's gonna probably cost me $1,000 an hour. And this guy, he comes in here with he's muscular, he's big, he's probably, making money, at Lionsgate, doing all kind of things and they can't afford you, right? Or they don't have access to you. So what resources are out there that could maybe help them manage these costs, whether they be federal, government, local, internet-based websites? Where would you direct people that, again, don't have the resources to retain good counsel?
The short answer is, unfortunately, sometimes having a good lawyer, which means usually an expensive lawyer, is that's the game changer. That's really where it comes down. There's nobody that's really deep in the game in this field without one. We've got multiple outside law firms, and we spend buku bucks every year dealing with valid claims, dealing with flimsy claims. And unfortunately, sometimes there's people out there that are innocent, that genuinely believe that they were injured people, but they don't have an advocate. They can't afford one. We get pro se plaintiffs all the time. People that go to court, they find their way to court. They get federal copyright infringement claims filed against us, and they manage to work their way through the system, and they get their day in court too. So there is a lot of self-help.
Are they victorious? Those pro se?
Not against us, no. But
Got it.
Sometimes the fight is the loss. If we spent $200,000 in attorney's fees just to get rid of a frivolous lawsuit, who really won? Maybe we should have just given the guy $20,000 up front just to kind of get out of our hair, for the nuisance value. So there are some self-help options out there, but for the most part, you really do need to lawyer up. It's one of the themes that Lawrence touched on when we first started this, is that you really got to lawyer up. Whoever you are, you got to
find the money.
Yeah. They say, someone that represents himself as a fool for a client. And in this space in particular, where not everything is intuitive, like copyright law, trademark law, is not as simple and straightforward as a lot of people think. People do think like, hey, you had an explosion with guns in your movie, and I had explosions with guns in my script, and you had a guy named John, and I had a guy named John, and in their mind, they genuinely believe they got what's fleshed out as a copyright lawsuit. They get themselves in a lot of trouble by, stepping on Darth Vader's cape, dragging us into court, incurring, losing, and then we get awarded our attorney's fees. And now not only did you lose, but now you owe us $150,000 in attorney's fees. We get this quite a bit, where we'll offer the people, say, look, just stand down. We won. You owe us $150,000 in attorney's fees. The court just issued that. We're willing to walk away from that if you're willing to walk away. But sometimes, folks don't want to. They don't back off. And if they had a good lawyer to kind of get them to back off the ledge a little bit, they could save themselves a lot of grief. So in terms of specific resources, I don't know that I have any necessarily offhand. The internet is, I Google stuff. I'm a lawyer, and I still Google stuff. I call friends. I call people to bounce things off of. And hopefully, if you're out there, you're not out. You don't have an actual lawyer. Hopefully, you're not just out there in the wilderness, literally by yourself. I mean, get a hold of somebody that knows more than you do, and just start asking questions.
I'm curious. Do you ever find yourself opposite a legal services lawyer in any of these claims?
No, like Lawrence was saying, at this level, at this point, you're not. You'll get a hack every now and then. Someone that gets a client that he thinks either he doesn't understand his client's claim, or he thinks he can just get his name in the paper, or he thinks he can just shake some money out of the big money tree. But for the most part, you're dealing with some of the best people in the business. It's high stakes. But like I said, we've dealt with a lot of people that represent themselves. Some of whom genuinely feel like they've been injured and infringed upon. Some of whom hate to say it, but have had some mental issues and mental health issues. And you can tell you're in a lawsuit with somebody who's smart enough and bright enough to get into court and to jump through several hoops,
but not capable.
But you can't get them out quickly, and it costs a lot of money. So,
Lawrence, did you want to add to that?
Yeah, I mean, well, not every lawyer costs $1,000 an hour. I know of one or two out there that are less than that.
Okay.
But in all seriousness, I mean,
I know, right?
there are a lot of resources. I mean, one, I think doing your research on the internet, I can think of the Black Entertainment and Sports Lawyers Association. BESLA has
great organization.
Tons of lawyers in every discipline within the entertainment and sports industries.
And by the way, just a plug. So Lawrence is chairman of that too, right? Okay,
I am.
Yeah, so pull up on that. Chairman of all things entertainment, Lawrence Hinkle II. Here we go.
Well, on that piece, I love being involved in that organization, but there are lawyers involved in that organization from throughout the country in every discipline, and I'm sure that the per hour rate varies greatly within that organization.
Totally.
And if you go to some of the bar associations, Beverly Hills Bar Association, California Bar Association, some of them do have pro bono programs. I mean, there are lawyers that dedicate a certain amount of their time each year in pro bono matters. So, if you beat the bushes enough and make enough phone calls and especially if you've got a real claim, at some point you can find somebody to help you. Like,
may not be Marty Singer, but
you definitely won't.
Well, no, you can't say definitely, because if you get a good claim for that man, and you don't have to give him $1, but if it's a good claim, whether you're Michael Jackson or Mike, nobody knows your last name, you may have Marty Singer on your team.
Well, I mean, there's a lot of considerations that go into whether or not someone takes on a client, and it's not always money.
Exactly, that's a great point. Yeah, sometimes it's just the shine. These guys, some of these lawyers just want to shine, man. And get their day in federal court or in the Supreme Court, right? 2 Live Crew or something like that. But one thing I'll add to that too is, I've always thought that law school clinics could be helpful. Maybe not with like litigation issues, like civil issues, but just kind of figuring out just basic, fundamental contract issues, copyright issues. These law clinics are like law schools that have a clinic program designed to serve the community in some of the more basic, rudimentary areas of legal issues, whether it's criminal, civil, or even do maybe probate or chancellery. But anyway, but listen, brothers, thank you guys again for coming out and being part of the Brooklyn boardroom. Again, 2 gladiators in the room, heavyweight brothers that you want them on your side if you're going to be in court. And if anyone watching this can afford to hire this man over here or can bench what this man could do in the gym, reach out. May have a new friend, may have a new partner. But thanks again for coming out to the Brooklyn boardroom. This has been fun. Definitely come back. And here we are. And find us on YouTube at Brooklyn Boardroom.